Hi, and thanks for tuning in. I'm Dustin Saldarriaga, an immigration attorney with Scott Legal PC in New York City. Imagine the following situation. You were born in the US and have lived here your entire life. You've had a US passport for years. One day, you apply to renew your passport, but instead of receiving a new one, you get a letter from the US Department of State saying that your application was denied because one of your parents was a diplomat at the time of your birth. As a result, the letter says you were never a US citizen. Believe it or not, this exact scenario happens with some frequency. In fact, our firm works with individuals who have spent decades believing they are citizens only to receive a letter from the Department of State informing them otherwise. In this video, we'll look at why this happens and what options are available to anyone who happens to receive this news. Let's start by taking a look at how the government can make the argument that someone born and raised in the US is not a US citizen. One of the very few instances in which a child born on US soil does not receive US citizenship is when they are born to a foreign diplomatic officer. In the language of the 14th Amendment to the US Constitution, such an individual is not born subject to the jurisdiction of the United States. Applying this to our earlier example, an individual whose application to renew their passport is denied does not actually lose their US citizenship. Instead, in the eyes of the government, they never actually had US citizenship to begin with. But why would the government raise this issue now? The US government does not appear to have a central list or database of people who were born in the US to a parent who is a diplomat. And the government also doesn't appear to systematically check the parents' occupations when someone applies for a passport. As a result, the government will sometimes issue a US passport to an individual who presents a US birth certificate without confirming the parents' occupation and whether they have full diplomatic immunity. After the first passport is issued, it's usually a straightforward process to renew it. Usually, this only requires that the individual submit their old passport in order to receive a new one. This usually doesn't give the government a reason to go back and confirm the parents' occupations and whether they had full diplomatic immunity at the time of the applicant's birth. However, if someone is applying for a passport for the first time as an adult, or if their passport was damaged or lost and they need to replace it, they might be required to submit their birth certificate. If the birth certificate says that they were born in a location where diplomatic offices are common, the Washington, D.C. area, for example, and if it shows that the parent's occupation was diplomat, this could cause the government to go back and confirm whether the parent had full diplomatic immunity at the time of the applicant's birth. If they did have such immunity, this would result in the passport application being denied. If this happens to you, what are your options? First, confirm whether your parent was in fact a foreign diplomatic officer at the time of your birth. It's always good to check the government's work to see whether they made a mistake, which they do. You can do this by confirming whether your parent actually did have full diplomatic immunity at the time of your birth. You can do this by checking the Department of State's Blue List, or if your parent was a UN representative, the Blue Book. These lists give the names of those individuals who served foreign states and international organizations, and as such, are generally immune from any form of arrest or detention. We'll include a link to these lists in the description below. If your parent's name appeared on the Blue List or the Blue Book at the time you were born, it's very likely that you were not born a US citizen. One notable exception is if your other parent was a US citizen or US national. If your parent's name appeared on the Blue List or Blue Book at the time you were born, it's very likely that you were not born a US citizen. One notable exception is if your other parent was a US citizen or US national. If your parent's name does appear in the Blue List or Blue Book at the time of your birth, and if your other parent was neither a US citizen nor a US national, then you likely had full diplomatic immunity at birth and therefore are not a US citizen. If your parent was a foreign diplomatic officer, the next step is to determine whether you have maintained continuous residence in the US since your birth. A person who was born in the US with full diplomatic immunity may have the option to register as a lawful permanent resident. These individuals have an expedited path to U.S. citizenship as long as they have maintained continuous residence in the United States since birth. As a result, once you have determined that your parent does appear in the Blue List or the Blue Book, the next question is whether you ever, since birth, departed the U.S. with the intention of abandoning residence there. Keep in mind that continuous residence is not the same as continuous presence. As a result, it is possible that you have maintained U.S. residence even while you attended school in your parents' home country, for example. The relevant question is whether you ever departed from the U.S. with the intention of abandoning the U.S. as your residence. If you attended school outside the U.S. but always returned to the U.S. to be with your family, for example, you arguably maintained U.S. residence. Pieces of evidence that you might use to show that you have maintained U.S. residence can include, for example, school or medical records in the U.S., documents showing that your family maintained a physical home in the U.S., and documentation of your or your parents' travel and work history in the U.S. It's helpful to think broadly about any and all evidence that might show that you maintained continuous U.S. residence, which a skilled lawyer might be able to help you with. If you are able to gather proof that the U.S. has remained your primary residence since birth, you may apply for a green card. If the green card application is approved, the date of permanent residence will be your date of birth. This means, depending on your age, that you may be able to immediately apply for U.S. citizenship. On the other hand, if you have broken continuous residence in the U.S., you would want to consider other paths to a green card. If you were born in the U.S. to a foreign diplomat and then broke continuous residence in the U.S., your path to U.S. citizenship is the same as for any other person who wants to pursue a green card. As a result, you would need to consider whether you have any family ties to the U.S. that might qualify you for a family-based green card. Or you may consider employment or business-based qualifications that might allow you to pursue an employment-based green card. Now, one aspect of this that feels like salt in the wound to anyone who has received this rejection from the Department of State is that holding yourself out as a U.S. citizen when you are not one can have severe immigration consequences. For example, applying for a U.S. passport, voting, or applying to work as a U.S. citizen when you are not one can have severe immigration consequences. As a result, when applying for an immigration benefit, it is usually important to disclose to the government that you have held yourself out as a U.S. citizen in the past, but that you did so with the genuine belief that you were a U.S. citizen and that you therefore deserve prosecutorial discretion. If the government agrees, these past actions should not be a bar to your path to a green card. We hope you found this video helpful. If you did, please click the thumbs up and subscribe buttons below to stay updated on future videos about visa options and travel to the U.S. Thank you for watching.